You are listening to the Justice in Heels podcast with me, your host, Danielle Hayward. Join me as I discuss interesting legal topics with inspiring female legal professionals who paved the way for the rest of us.
Hello and welcome to another episode of the Justice in Heels podcast. Today I am joined by Tshireletso, who is going to tell us a bit more about intellectual property law. Welcome to the podcast.
Thank you, Danielle. Thank you for having me on your podcast. I'm very excited to share my insights on intellectual property law.
So before we start, do you maybe want to tell our listeners a bit more about yourself?
Okay, so by way of introduction, I'm Tshireletso Tlholoe. I'm an attorney specializing in the prosecution and registration of trademarks. I assist clients with adopting the best approaches to build their brands, protect their brands globally, but also with a particular focus in Africa. And I do so by conducting clearance searches, trademark portfolio reviews, and also by facilitating the entire filing, prosecution, and trademark registration process.
Fantastic. Okay,
Yeah.
so I think we're going to learn a lot today, but can you maybe just tell us what types of intellectual property actually exist in South Africa and how do they actually differ from each other?
Oh, okay. So there are different forms of intellectual property, and each form of intellectual property provides a distinct scope of protection, right? So there are four main types of intellectual property that I want to speak about today. So the first would be your trademarks, then you have your designs, then you have your patents, and you also have copyright. Right. And all these differ in terms of the scope of protection because a trademark will, for example, protect a name, a logo, any sign that's basically capable of distinguishing. Copyright, on the other hand, would protect creative works. So these are your literary work, your artistic work, your musical work. So like your novels, lyrics, those type of works qualify for copyright protection. And you have your designs. Designs basically protect the appearance of a specific product, whether it's the shape of the product, whether it's the pattern of the product, the ornamentation applied to the product, or also like the configuration of the product. And then you have patents. Patents protect inventions. So if you come up with a very cool invention, that would qualify for patent protection. And I know a lot of people struggle with distinguishing between the different forms of intellectual property. So to assist, I actually brought an example and I hope that it will help. So I have like a Gaviscon bottle here. I don't know if you can see it.
Yep.
Cool. So just to illustrate the different forms of intellectual property, you have the name Gaviscon, and then you have it's sort of a human torso with a burning heart logo. So that's the name and the logo will qualify for trademark protection, right? And then you have, it's like a manual with instructions on how the product works. That content over there would fall under copyright. And then you have the substance inside. So the composition of the substance would fall in the area of patent. So it's an invention of in terms of a substance. And so if this bottle had a specific design that's fancy and that's appealing to the eye, that would be protectable by design also. So I just wanted to use this bottle to illustrate because I do get a lot of questions where people are like, I want to patent my company name, and I'm like, okay, there's a difference between a trademark and a patent. So yeah, I hope this illustration helps.
Brilliant. Thank you so much. Yes, it makes it much more easier to actually understand the difference between these intellectual property forms. Can you maybe tell us why should one register a trademark? What is the process? What is the benefits?
Okay, so I'll start by saying that a trademark is any sign that is capable of distinguishing the goods or services of a specific person or enterprise from those of another, right? So it can be a word, it can be a logo, it can be a slogan, or any combination of these elements. So basically, as long as your mark is capable of distinguishing, then you can secure trademark protection, right? So, and I just want to say that trademarks are used by businesses to ensure that customers can identify the source of the goods or services. So it sort of serves as a badge of origin. So when I drink a certain, if I drink a certain cool drink, or if I eat a certain pizza, I should be able to identify the source of that product by just looking at the trademark, which is the name or the logo. So trademarks are very important in that sense because they serve as a badge of origin, right? And if you want to secure protection for your trademark, there are certain requirements that have to be met. So the first requirement would be that the trademark should be capable of distinguishing. So by capable of distinguishing, you mean that it should be capable of functioning as a trademark, either inherently or by virtue of extensive use, right? So when adopting a good brand, I always say that go for brands that do not ordinarily have any meaning, right? Especially in relation to the goods or services of interest to you. So if someone wants to register pure water in relation to water, that's a bad mark. Or if you want to register sweet treats in relation to chocolates or sweets, that's a bad mark. But if you come up with a mark that doesn't have any meaning, that's a good mark. Or you can have a mark that has a dictionary meaning, but does not bear any specific meaning in relation to the goods or services of interest to you. For example, if I want to register Apple for apples, that's bad. But if I want to register Apple for electronic devices, that's a good mark, right? But then you do get marks that are not capable of distinguishing, but because of extensive use, they do serve as trademarks. For example, tracker in relation to tracking services. So that's not on the face of it capable of distinguishing, but because the brand has been used for extensively for numerous period of time in the market, members of the public have come to associate that brand with the specific company. Yes, and the second requirement, which is very important in my view, is that the trademark should be available for registration. So essentially, you cannot adopt a trademark that's already existing in the market, or that someone has already filed for registration. So what we typically do in those circumstances is that we conduct clearance searches. So we look at the trademark register to see if the mark is available for registration. And at times we also conduct in-use investigations to see if there's anyone actually using this mark in the market that may. So you just want to avoid a situation where someone might sue you at a later stage for using their mark, right? And I just want to mention that trademarks are registered in specific classes depending on the nature of the goods or services in relation to which the mark is proposed to be used, right? So we currently use the niche classification system. In terms of the niche classification system, trademarks are registered can be registered in 45 classes. So class 1 to 34 covers goods, and class 35 to 45 would cover your services, right? So I'm just going to use Justice in Heels as an example. Yeah. So Justice in Heels is used in relation to podcasting services. So if you file your trademark, then we would look at class 38 and class 41. Class 38 covers specifically podcasting services, and class 41 would cover your educational content to be used in podcasting, or provision of entertainment in podcasting service, in podcasting settings, right? And if you later want to extend the use of your mark to something different, for example, let's say you want to develop a software application where people can access your content by downloading it from that application, then you can also extend protection of your mark to class 9, which covers software applications or downloadable software, right? And if you later decide to use it in class, I mean, if you later decide to use it in relation to clothing, you can also file it in class 25, which covers clothing, footwear, headgear, and all of that, right? And insofar as the benefits of registering a trademark are concerned, I just highlighted a few benefits which are very important in my view, right? So the first is that if you have a registered trademark, or if you filed your trademark, you have an easy proof of ownership, in the sense that if there's a dispute about who owns this trademark or who came up with this trademark, then you can easily access the registry's records and be like, hey, I'm the proprietor of this trademark, or I'm the applicant in relation to this trademark. So it just provides you with an easy proof of ownership. And if you have a registered trademark, it tends to attract partnerships or licenses. So if your brand is doing well in the market and people are loving what you do and loving your work, they would basically be inclined to partner with you to also use your mark in relation to similar goods or services. For example, if someone might be like, hey, I actually like Danielle's podcast and I want to start my own podcast and use her brand. So you can enter into a license agreement, and obviously that would be with the payment of royalties. So it would in essence generate income for you. And then the third thing is a trademark is an asset. It's an asset which has value. So if you register a trademark, it sort of enhances the overall value of your business, especially when it comes to selling your business. If you ever decide to sell your business, it increases the value of your business in the sense that you have more bargaining power and you can charge more for your business because you have a registered trademark in respect of the business. And a cool benefit that's associated with registering a trademark would be in the case of counterfeit goods. So we all know that counterfeit goods are a phenomenon, not only in South Africa, but across Africa. And what I want to say is that if you register a trademark in South Africa, right, you can you can record your trademark with the South African Revenue Service Customs Division. So what they will do is that they will assist you by preventing the importation of counterfeit goods into the South African market. So if anyone wants to sell counterfeit goods in South Africa, what they would normally do is that they would detain the goods at customs, and they'll call you as the proprietor and be like, hey, we actually came across these goods which are actually which look very sus or very suspicious, and then you have an opportunity to go and inspect the goods. If the goods are actually not yours, or if they're infringing to your trademark, then they can actually destroy them. We see this a lot with clothing, shoes, electronic devices. You know, they are very common when it comes to counterfeit. Yes. So I just want to also speak on the process of obtaining a trademark registration. It's quite lengthy, but it's very beneficial for the proprietors, right? So first thing first, we normally conduct clearance searches of the trademark register to see if your mark is actually available for registration. It's very important to do that because you don't want to find yourself in a situation where you spend so much money branding your goods or branding your business only to be met with infringement proceedings later on. For example, let's say you want to use a specific brand in relation to a restaurant, then you don't conduct searches, you just use the mark, or you just file the mark, and then you proceed to brand your merchandise, your establishment, your menus, your cutlery with that mark. And then later you faced with infringement proceedings. It's a problem because now you wasted so much money, and now you're going to have to rebrand, you understand? So it's very important to conduct trademark availability searches just to see whether the mark is available for registration, right? And I always advise that you seek the assistance of a trademark attorney when doing so, because some people would be inclined to do searches on their own, but they don't really know what to look out for. So as trademark attorneys, we're trained to know what to look out for. So sometimes you might think that your mark is not available for registration, but it actually is, because the mark you're concerned about is vulnerable to abandonment, or it actually lapsed by reason of non-payment of the renewal fees. In other instances, the mark is not available for registration because it's confusingly similar to an existing mark. So remember, a mark, you can't adopt a mark that is identical to your mark, or confusingly similar to your mark. So I know a lot of people think, justice, I can use justice in boots or justice in sandals, because it's not justice in heels, but actually there's confusing similarity there. And we know as attorneys what to look out for. So it's always appropriate to consult a trademark attorney if you want to register your mark, because they can do proper clearance searches. And then we prepare the trademark application with the details of the trademark, the details of the proprietor or the applicant of the mark. And then once that's done, we file the application with the Companies and Intellectual Property Commission, with their office. Then once that's done, then we wait for the registry to examine the mark. So the registry will basically check if the mark meets the formal requirements and the substantive requirements. If the registry is happy, they will accept the mark, or they may conditionally accept the mark, and then you have to do what is required. So if the registry is happy, they will accept the mark, and they will then we will arrange for advertisement of the mark in the official journal, right? So when you advertise the mark, you're sort of giving third parties an opportunity to inspect the mark and to file opposition proceedings if they are not happy with the registration of the mark. Once again, that's why it's very important to conduct clearance searches, because you don't want to pay all that amount to file your trademark, and then later it's faced by opposition proceedings. So if a third party does not oppose your mark, then your mark will proceed to registration, and the registry will issue a registration certificate. I might mention that the opposition period is for 3 years. I mean, 3 months, sorry, 3 months. So third parties have an opportunity to file an opposition if they are not happy with that mark for 3 months. Yes, and then the registration certificate will be issued if there are no oppositions.
So
Yes,
how
so
long is
that's
it valid?
So a trademark is valid for a period of 10 years, and then you can renew it every 10 years, basically.
Fantastic. So before we
Yes,
continue, I just want to ask you a very interesting thing. So I'm
yes,
sure that you've seen a lot of people who are now on the Stanley train. Everybody's buying their Stanley cups.
yes,
And a lot of
yes,
people
yes,
are actually buying the Stanley Dukes because the Stanley
yes,
cups are just too expensive. So can
exactly.
you can you maybe explain to us how intellectual property actually can affect like all of these companies making the Stanley dupes?
So it goes back to what I was saying, that so for example, you'll see the cup has a specific design to it. I'm not sure as to whether this design is registered or not, but if it is, then people imitating the appearance of the cup, that would constitute infringement, right? And it's just very problematic, because brands spend so much money in like creating their product and making sure that their product is sort of appealing to members of the public. And when people actually copy, this is actually counterfeiting. When people copy these brands, it just takes so much away from their profit. So in the event that the design is registered, then there's recourse for infringement proceedings. But there's also common law remedies available in the event that you haven't registered your intellectual property in this case. So yeah, that goes back to what I was saying, that it's very, very important to register either your design or your trademark or your patent, just to make sure that it's easier for you to enforce your rights in the market. Yes.
Fascinating. Thank you for
Yes,
that.
yes, no
So
problem.
Moving on to copyright, can you maybe tell us what is copyright and what type of work will be protected by copyright?
Okay, so copyright is basically a legal right that grants authors exclusive rights to control, basically exclusive rights over their original work, right? It protects the work of an owner or of an author from being copied. So works that are basically eligible for copyright protection would be literary works, artistic work, musical works, computer programs, cinematography, films, broadcasts, and sound recordings, right? So these works are protectable under copyright, and also it can basically take the form of a novel, a painting, a drawing. So that would all fall in the domain of copyright. And I just want to mention that the main difference between a copyright and a trademark is that a trademark, you can register a trademark, but you can't register a copyright. So with a copyright, it automatically subsists in the work. So you don't have to register. As long as your work meets the requirements of a copyright, then you will have protection. But what I actually want to speak about on is the whole ownership aspect of copyright law. So the general rule in terms of copyright law is that the creator or the author of the work is the initial owner, right? This means that a person who creates the original work, whether it's a book, whether it's a painting or film, automatically holds ownership rights in that specific work. However, what most people don't know is that there are specific exceptions to this general rule. And this is where most disputes occur. So for example, if you are acting in the scope of your employment, so if you create a work under the scope of your employment, then you won't necessarily have ownership rights in respect of that work. It would fall within, the ownership would be in the employer. So basically the employer would be the owner of the copyright. So for example, if you work in a newspaper company and you write a really nice article, or you write a really nice commentary on specific events, because you're acting in the scope of employment, that the ownership of the copyright will vest in the employer. And also we see this a lot with commissioned work. So if you commission someone to create a work such as a painting, a drawing, or a film, you are not necessarily, so the copyright will not necessarily belong to the person getting the work, but it will belong to the person or entity that actually commissioned the work. So, but all of these can be avoided or cleared out by way of agreement. So in these cases, it's always best to have an agreement in place illustrating who is the owner of the copyright, and how the ownership will be controlled. So yes, so I just wanted to clear that out, because a lot of people think that if I created this, if I'm the owner, if I developed this application, I'm the owner automatically, but there are rules on that. Yes.
Interesting.
Yes.
So, you know, in some or in most books, actually, I think like actually all books that I've read in my life, you have that little part at the beginning of the book that says uh copyright, and then that @ sign, and then the author's name or the publishing house's
Yes.
name. Is that then actually like necessary to actually do that?
It is very necessary, because it's one of the ways you are educating the public that you have copyright, or you have ownership over this copyright or this work, right? So normally we would advise clients to use the C symbol, with a ring, and the year of the year of creation of that specific work. That's one of the ways in which you can protect your copyright from infringement. And also you can have a disclaimer. You'll normally see it in books and also on websites. People will have disclaimers at the bottom, basically saying that please note that this work is protected by copyright. So these are the ways in which people can actually educate members of the public that this work is protectable in terms of copyright, and do not actually copy or imitate or adapt my work. Yes.
Okay, thank you.
No.
So copyright then, how long is
Yes.
it valid? Do you need to renew it? How does that process work?
So with copyrights, generally it's for the lifetime of the owner and 50 years thereafter after their death. But it also depends on the specific type of work in question. Whether it's a literary work, whether it's an artistic work, whether it's a musical work. So yeah, but generally it's usually the lifetime of the owner and 50 years thereafter. Yes.
So before we move on to patents, is there anything else that you maybe want to tell our listeners about copyright before we move on?
I think it's very important to educate the public. You know, unlike other forms of intellectual property, you can't register copyright. So the onus is on you to educate the public that you're actually claiming ownership in a specific work. And like we said, the use of the C symbol followed by the year of creation, or the use of a disclaimer, would generally assist you with informing the public that this is your work and you are the owner of the work, and you know, you're legally protected for this work. Yeah.
So you've mentioned that patents are used to protect inventions. Can you maybe tell
Yes.
us what's a patent, what's an invention, and what type of invention can be protected by patents?
Okay, so a patent is basically a statutory monopoly right that provides for the protection of an invention, right? So it grants the inventor a negative right to prevent others from exploiting the invention for a specific period of time, right? And in return, the inventor must fully disclose the invention, so that other parties may exploit the invention once the duration of the patent has lapsed, right? So a patent can basically be you can secure patent protection for basically any invention that is not specifically excluded by the Act. So the Act has specific exclusions. So the first one I can think of is discovery. So if you discover something that already exists, you can't get patent protection for that because it's already there, you know. And the other form I can think of is methods of treatment. So for example, let's say you're a doctor or a surgeon and you come up with a method of treating a specific disease. You can't you can't obtain a patent for that, because we don't want a situation now where doctors or surgeons are scared of performing certain method of treatments because they're scared of being met by infringement proceedings later on. There's that, you can't obtain a patent for that. And the other form I can think of is a method of doing things, like a method of playing chess. You can't secure a patent protection for that, but you can secure patent protection for any invention as long as it's not specifically excluded by the Act. And it can be the smallest of things and it can be the largest of things. So something like a razor blade, right, can qualify for patent protection. Or I'm just trying to think of a cool example. Let's say you invent a biodegradable material, right? That's different from the other forms of packaging. So it's a biodegradable material, packaging material, which degrades faster than the other ordinary forms of material. So you want to save the earth and be eco-friendly and whatnot, because it's a new way of doing things and it's something that's not out there. You can secure patent protection for that. So another example of an invention that would qualify for patent protection would be a vaccine or a cough a vaccine or a cough mixture, but it has to provide a technical solution to a problem. So it can't be something that exists. It must be something that's actually new and provides a new solution to a problem. So that would be that would qualify for patent protection. And also, I just want to mention that there's specific requirements to be met. So the invention must be an invention by decision. So in other words, it must not be something that's specifically excluded by the Act from patent protection. And the most important one, in my view, is that the patent must be new. So there must have not been any existence of the invention at the time of filing your patent application, right? And the invention must involve an inventive step. It must not be obvious to someone who's skilled in the particular technology or industry. So it must be something that's actually innovative. Like I said, it must be something that brings about a technical solution to a problem. And lastly, it must also be capable of being used or applied in trade industry or agriculture. So as long as you can use that particular invention in the trade industry or agriculture, then you can secure patent protection for it. But the most important element that I want to speak about, the requirement, that I want to speak about is that a patent must be new. It must be novel. So it must not be something that's already out there, right? And one of the most important advice that we give clients is that don't disclose your invention before you speak to an attorney, right? And people come up with these real cool ideas, and most of them take the form of an invention, and they disclose them with their friends and whatnot. Next thing, the invention is already published, and you can't secure patent protection for an invention that's already out there, that's already existing in the market. So it's very important to speak to an attorney before you communicate to anyone about your invention. Yes.
So something I've heard, well, not a lot, but more times than I care to mention, is many people are so afraid that the trademark attorney or the patent attorney is going to steal their invention or their idea.
No.
Can you maybe explain to our listeners like why they should not be afraid that that will happen?
No, they should not be afraid, because obviously we are governed by the principle of confidentiality. So anything you say to us is obviously confidential, and we will not disclose it to anyone. And also, I just want to say that it's always advisable to seek the assistance of a patent attorney, because from the first consultation, you'll be able to know if your invention is worth protecting or not, or if it will qualify as an invention or not. So there's that element. And I know a lot of people are scared of approaching trademark attorneys or patent attorneys because they're like, no, it's very expensive. I'm going to spend millions. But in most cases, the first consultation is free. And you'll be able to get a lot of information from the first consultation. You'll know if you're wasting your time with a certain brand or a certain invention or a certain work. Or alternatively, you might hear the good news, and then an attorney will assist you with actually protecting your intellectual property in that case. So it's always advisable to seek the assistance of an attorney.
Fantastic. So do you want to maybe summarize for us what are some of the things that the public and businesses should keep in mind when trying to protect their intellectual property?
So first things first, understand your intellectual property. So be able to identify the specific form of intellectual property that apply to your product or your business, right? So I gave with the Gaviscon example, there are different forms of intellectual property that actually apply there. And each type of them offers a different form of protection, right? Secondly, would be to register your intellectual property for those forms of intellectual property that are capable of being registered. So an invention, a patent is registrable. Sorry, let me just say this correctly. So you can secure registration for for an invention by way of patent protection. You can secure registration for your name or your logo by way of trademark. You can secure registration for the design of your product by way of design law, right? So just if your product or your service offerings can be protected by way of statutory protection, then do that, because it's always best to have statutory protection as opposed to having your work just exist in the market. And what we often tell clients that you need to educate your audience or the public about your intellectual property. So, for example, with trademarks, right? If you have a trademark, you can use the TM, I don't know if you've seen the TM symbol or the R symbol next to your trademark. So the TM symbol is used if you have a trademark that has not yet proceeded to registration, then you use the TM symbol. But if you have a registered mark, then you can use the R symbol with the ring one. So this is basically just to inform members of the public that, hey, I'm actually claiming rights in this name or in this logo. So don't copy it, don't imitate it, you know. So that's one of the ways in which you can protect your intellectual property. And also with copyright, using the C symbol followed by the year of creation, or having a disclaimer basically telling the public that this work is actually protectable under copyright, then that's a nice way of actually educating the public. And one of the other ways in which you can protect your brands is by monitoring the market and actually enforcing your rights. So by monitoring the market, what I'm saying is you need to keep a lookout of potential infringers. Just make sure that you know, just make sure that you monitor your brand. And if you come across anyone trying to mimic or imitate your brand in the market, then you must take action against them immediately, because it starts with one person. Next thing, 10 people are using your brand. And when that happens, it's very difficult to actually enforce your rights, because the 10th person will tell you that, oh, but 9 other people are using your brand, so what's stopping me from doing that? So it's always important to take action immediately. If you find anyone using your brand without your permission, basically making unauthorized use of your brand. And also it prevents dilution, in the sense that it prevents a situation where your brand loses its distinctiveness in the market. So you want your audience or your customers to be able to associate your service offerings or your products with you exclusively. So when you have other people doing the same thing using your brand, it becomes a bit blurry, because then we don't know, okay, is this podcast by Danielle or not, you know? So it's very important to monitor the market and also enforce your brands. And with patents, like I said, just to make sure that you don't disclose your invention to third parties. And if it's, there are cases where it's absolutely necessary to do so, but then patent attorneys can assist you with drafting a non-disclosure agreement. So if you have to disclose your invention to someone, then you can have an agreement in place whereby it won't fall within, the invention won't fall within the public domain. So that's the ways in which you can protect your intellectual property. Yes.
Fantastic. Thank you so much for all of the knowledge that you shared with our listeners today.
No problem.
I learned a lot. Many
I'm
things
happy
that I
you
did not
did.
know.
Have you registered your trademark also?
Not yet. I still need to
Okay.
do that.
At least now you know, but also, like I said, you can use the TM symbol in the meantime, just to make sure that you educate the public that this is your brand and they can't exploit it,
Okay, fantastic. So can you maybe tell our listeners where they can reach you?
So you can reach me on LinkedIn, Tshireletso Tlholoe, and I'm also on Instagram, Tshireletso Tlholoe there also. Yes.
Thank you for listening to this episode of the Justice in Heels podcast. If you enjoyed this episode, feel free to share it with your friends on social media and tag us. As this podcast has a legal element, Just a quick disclaimer that all views expressed in this podcast are not necessarily the views of the firms, companies, or brands that we are associated with. Until next time, goodbye.